let's talk about whether the jury foreperson can be added to the long list of culminating issues that the federal court may be interested in hearing. So let's start from the start. How did the jury foreperson get picked? Were they hand-picked by the judge, or did their number get drawn out of a barrel? Many are confused as to how it happened, and so I went and found the footage, and here's how the jury foreperson was chosen.
Now, different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own foreperson. In Massachusetts, the judge is responsible for selecting a foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations, however, in that sense is exactly equal with all the jurors. I am going to ask juror in seat number 1, juror number 400, would you be our foreperson, please, sir? Thank you.
So, I guess that settles that then. The next question I hear you ask is, how true is this? Is Judge Cannoni's decision to appoint the jury foreperson in alignment with Massachusetts legal practices and guidelines? I have found that indeed it is. In Massachusetts, the practice of selecting a jury foreperson varies and can be the discretion of the presiding judge. While some jurisdictions allow jurors to choose their own foreperson, Massachusetts law permits judges to appoint the foreperson themselves. This approach is reflected in the Massachusetts trial court jury instructions, which state, exactly as she said, juror number blah, state the name of the juror, I appoint you to be the foreperson of this jury. This instruction indicates that the judge has the authority to designate a foreperson. There is, however, a conflict with case law. Is anybody surprised? While Massachusetts jury instructions suggest that the judge may appoint a foreperson, previous case law and constitutional principles emphasize that jury deliberations must remain independent from judicial influence. This conflict arises because judicial selection of the foreperson could interfere with jury independence. Past case law prioritizes protecting jury autonomy and preventing judicial influence over deliberations. And let's face it, none of us have any confidence whatsoever that the appointed foreperson did not contribute to a biased deliberation. And we do have evidence of this, but I'll come back to that in a minute. As far as the case law is concerned, it emphasises the jury's independence. So, Commonwealth v. Francis, 2007, says the Massachusetts Supreme Judicial Court ruled that jury deliberations must remain independent and free from judicial interference. Any attempt by a judge to influence the jury decision-making, including selecting who leads deliberations, can compromise the jury's neutrality. There's also US Supreme Court precedent under Parker v. Gladden in 1966. It says the US Supreme Court ruled that external influence on jury deliberation violates due process. If the judge's appointment of the foreperson led to suppression of certain votes, it constitutes an external influence. And I think we even have evidence of that. But essentially, case law says that if the judge's selection of the foreperson had any effect on the fairness of deliberations, it is a constitutional issue that overrides any procedural rule of the state. Judge Cannoni's assurance that the foreperson is equal to other jurors ignores the fact that the foreperson has a significant influence over the process. For example, the foreperson decides the order of discussion, controls the pace of deliberation, calls for votes and determines how they are organised, and communicates with the judge on behalf of the jury. If Judge Cannoni's hand-picked foreperson suppressed acquittal votes, that is evidence that the selection process compromised the jury's neutrality. This falls under Remmer v. United States, 1954, the Supreme Court ruled that any external influence over jury deliberations is presumed to be prejudicial unless proven otherwise. This means that Judge Cannoni's selection of the jury foreperson should be scrutinised, especially given the allegations of vote suppression. So how do we know that their votes were suppressed?
It was 9-3, and you kind of wavered a little bit, right? Like they convinced you one way, and then like what you told me last time was it was 9-3, and you were kind of on the fence, and then you kind of came back, and there was 8-4. Is that an accurate depiction of what happened? Would you say it ended in 8-4 for guilty to not guilty?
That's correct.
Okay, and you, correct me if I'm wrong, you told me that you and one other juror wanted to ask the judge, Judge Cannoni, whether or not you were allowed to acquit on two of the charges and hang on the third, and that the foreman said, no, we're not going to do that. We have to decide on, it's all or nothing.
So it was not a question of whether we can acquit. It was a question on, can we make decisions on each individual conviction independently of each other
individual charge,
versus,
right,
so that was the question. It wasn't necessarily.
Right. So acquittal, conviction. Yeah. So like but you wanted to ask the judge, are we allowed to come to a decision on two of the charges and hang on the third? And the foreman said, that's not going to happen. No.
And it wasn't necessarily just the foreman, but there was a bunch of other opinionated individuals also kind of saying that, no, I think we have to look at it as a whole as opposed to independent. But clearly the person who was in charge at the time was the foreman. So word or their word was more pronounced.
So those notes that he would write, were those group efforts, those notes, or like, I mean, they were well written. Obviously, a lot of people have talked about those notes, and the SJC in particular looked at those notes, and he used the word charges plural, and that was a big the SJC cited that a bunch of times. He said that we are deeply divided on the charges, he said. And did you guys come up with that note together, or did he write that himself, or did ChatGPT write it? How did that get written?
It was written by the foreman with in collaboration with all the other jurors. So we all looked at it. We all kind of accepted it as such. Again, it was one of the questions that we wanted to ask the judge was for clarification on can we look at these charges individually? But ultimately, that kind of question was put down, and essentially we had no choice but to just, again, based on the group, right, or majority rule, to say that we were just going to ask one question, or it's an all or nothing scenario, as opposed to can be treated individually from each other.
It does seem like the jury foreperson did have the loudest voice in the group. And it doesn't make any sense that they took other questions back to the judge, but not that question, like the most important question. So the next question would be, were they confused by the forms? Is that why they didn't fill out any boxes at all?
Did he see the footage of Alan Jackson in court arguing with the judge about how the confusing juror forms were? And what did he think of that? Did you guys know that battle was going on inside the courtroom?
I do not know of that in particular. I never saw the footage, but I understand that it was very confusing. And again, unfortunately, it's a fallacy in the system that it wasn't clarified for us that we could look at each individual charge independently of each other.
There was also other stuff that this particular juror had said to Aidan previously in written interviews, which give us more clues about what the jury foreperson was saying and doing. In this part of his interview, Aidan asked, do you feel the jury foreman was bullying? The answer was, he was given the charge as being the foreman, and therefore we believe that he was the leader and that he knew what he was talking about. The letters to the judge regarding how we were going were well written. I don't know if it would have changed things if we'd asked that question about consensus of 2 of 3 the counts. To which Aidan asked, so 2 of the jurors wanted to reach out to Judge Canoni and ask her if you could acquit on 2 charges and hang on the 3rd, and the jury foreman said no? To which the answer was yes. He said it needs to be 100% of the charges with a unanimous verdict. Which makes absolutely no sense, because you would end up with guilty on 3 charges, or nothing at all. Anyway, Aidan follows up with, so why didn't you reach out to the judge? The reply was, because only the foreman is allowed to reach out to the judge. The foreman is the only one who can write the notes. And it was only 2 of us who wanted to reach out, but since the foreman didn't, it was 10 to 2. And they agreed that we had to be unanimous, and so no note was passed to the judge. This leads me to believe that the foreman not only suppressed their votes, but also suppressed their questions to the judge. Aidan went on to ask, did you decide on the murder charge on the first day? To which the reply was, I think we reached a full consensus of not guilty on the second day. Aidan asked, were there ever any formal votes on the murder charge to see where the group stood? The answer was, we did that multiple times, and it was consistent for charges 1 and 3. Eventually, we stopped voting on the murder charge because it was 12 to 0 every time. We spent the last 4 days entirely deliberating on manslaughter. To which Aidan asked, did the jurors discuss the verdict forms or want clarification? Or did they understand it fully? Was the jury divided on charge 2 because they didn't understand it? The reply was, some individuals were confused about it. One person read the whole thing out loud and made sure it was clear what the charge was and what we were going to vote for. So it was definitely discussed, and it was clear in individuals' minds what we were actually voting. And that's what caused us to send the vote that we couldn't reach a consensus. For some individuals, it was very clear that they were not going to move from their stance. So again, they left it up to the foreperson to fill out the form, who didn't fill out the form. But they were clear on what they were actually voting on. And the reason this matters is because of the federal habeas implications. Judge Canoni's appointment of the jury foreperson, and that foreperson's subsequent suppression of acquittal votes, as well as their refusal to tick any boxes on the jury forms, raises serious constitutional concerns. Because under Bracey versus Grimley, which is a habeas precedent, the US Supreme Court ruled that judicial bias or influence that affects the jury's impartiality is grounds for habeas relief. Another key habeas precedent is McDonough Power Equipment versus Greenwood, 1984. If a juror or foreperson is improperly selected and their influence affects the trial's outcome, it can be grounds for overturning a verdict. We also know that the 5 jurors who reported that the foreperson blocked their acquittal votes suggested that the judicial selection process directly impacted the case. This is strong evidence that the trial's outcome was unfairly influenced and should be reviewed in federal habeas proceedings. The multiple constitutional concerns it raises are 1. Unlawful jury manipulation, that is, the jury foreperson may have been pre-selected to favour the prosecution. External influence on the jury, a state police trooper under investigation himself played an improper role in jury oversight. 3. Obstruction of jury decision making. 5 jurors later came forward stating that the jury foreperson prevented them from asking questions, suppressed their votes for acquittal on 2 charges, and refused to fill out the jury form. And of course 4, judicial misconduct. Judge Canoni's actions may constitute an intentional attempt to control the jury's deliberations and verdict. The jury's neutrality and independence is a cornerstone of due process, and any effort to manipulate the leadership of the jury violates the 6th and 14th Amendments. So there was one more thing that this juror raised in written interviews with Aidan that I wanted to address. It was when Aidan was asking about the ARCA guys. So he said, but the ARCA guys were unequivocal that John's injuries didn't come from a motor vehicle collision. Clearly those who voted guilty did not find them convincing. What went wrong? And the reply was, the group in general felt that the defence was trying to derail us with them. A lot of people were saying guilty because these individuals came in and gave us this information. They couldn't say who was sponsoring them, whether it was an insurance company or, no offence, or it was you yourself. Of course, we all know that the jury's not even supposed to know who Turtle Boy is, which caused Aidan to ask the obvious, did you know who I was? We did know because there was someone in the jury who knew about you, and we talked about it a little bit. There was information being told to us by family members about what was going on with the media, for lack of better terms. Someone on the jury was telling us that you were in the courtroom and there were people who were talking about different angles. To which Aidan responded, so the jury guessed that possibly Turtle Boy paid for the ARCA experts, but no one suggested the feds? The answer was based on our charge, which was to follow the evidence, so we left it alone. So because of that factor, we didn't know who sponsored them, because the defence utilised them but the prosecution did not. So it was confusing on whether or not they were there to derail us, and some of the jurors felt strongly about that. I felt that there must be some truth in why they're trying to present this information, and why the judge would even allow them to testify if they weren't credible. I won't repeat all of the case law that does not support Judge Bev's ruling to not tell the jury who the ARCA guys were employed by. Rest assured, the prejudice that case law spoke of is being spoken of here by this juror. Aidan goes on, can you please clarify what you mean when you said that one of the jurors spoke to a family member who alerted them of my presence in the courtroom? The answer was, that was something we discovered in the middle of the trial. One of the jurors said they recognised your face in the courtroom, and from there other jurors talked about it, and then family members were telling them information. One of the jurors' family members said you were pointing out that one of the jurors was wearing a bow tie, and that wasn't my family members, but one of the other jurors' family members knew that that had happened. During deliberations, we discussed it a little more. To which Aidan replied, you were told not to talk about it when you went home, but it sounds like this juror talked to a family member at home who was watching my show or reading my tweets. This seemed to be a violation of the judge's orders, doesn't it? The answer was, the judge ordered us not to discuss the case. She knew and we knew it was everywhere. One of the things we were asked not to do was watch news coverage. I continued to work throughout the trial, and whenever my co-workers began talking about it, I left the room. Pretty sure we can all guess which juror that was. Clearly it was the foreman, and if the defence wants evidence of that, they can just get statements from the other jurors. But there's also other evidence that the jury foreman put into an affidavit himself. Aidan asks, the foreman filed an affidavit asking to have his name impounded, and specifically mentioned me as a safety threat. Are people afraid of me? Are they worried that I'm going to dox them? To which this juror says, and this is important, I think there's a public perception that the media may be a threat. There is also a perception that law enforcement and other individuals would seek revenge on the jury because we voted to acquit her on murder. So if you remember, the jury foreman was actually the first one to come forward with this affidavit. And notably, in that affidavit, they're not worried about the media or the law enforcement and other individuals who might seek revenge. No, they're on the same page as Aunty Bev, who, if you recall, overruled the defence and the prosecution about whether or not Aidan's name would come up in the trial. She decided that if the names came up organically, she would allow it. So what we're learning from this juror is only one juror knew who the alleged co-conspirator was involved with the witness intimidation allegations connected to Karen Reid. You guessed it, the jury foreman. The only juror that had access to the DA's office. If you recall, some of the other jurors later on did reach out to the DA's office and they were turned away. But this juror, the foreman, was able to write this affidavit to request sealing of the jurors' names and have Aunty Bev approve it. Notably, he's already retained counsel to represent him and write the affidavit. In point 9, he notes, I also recall testimony from at least one witness who described being harassed by individuals and her family being harassed because of their involvement in this case. And if that's all it was, he just heard someone say that in testimony, then how does he know the nature of that harassment? How does he know it's Turtle Boy that's being accused of that? How does he know that Turtle Boy's in the room during the trial? How does he know that the protests are linked to this harassment? Who is the so-called family member telling him this stuff during trial? Trooper Fanning, maybe? Why is he concerned about the demeaning and attacking nature of social media posts regarding the judge? Why is this entire affidavit all about Turtle Boy and protests? So the fact that this juror is on the same page as Aunty Bev, was chosen by Aunty Bev to be the foreperson, actively enforced Aunty Bev's all or nothing rule on the jury forms, failed to tell Aunty Bev that they'd acquitted on 2 of 3 counts, or did he? Effectively convinced the jurors that defence witnesses were detractors and to ignore their testimony, somehow obtained counsel to write an affidavit within days of the mistrial being declared, somehow has access to the DA's office where the others didn't, and appears to be very upset about disparaging comments regarding Aunty Bev on social media, and so on, all raises the following issues that should be brought up in the habeas petition. 1. Juror misconduct due to outside knowledge of a dismissed charge, i.e. the grand jury indictment that was raised during court to kick Turtle Boy out of the courtroom. 2. A tainted deliberation process, where the foreperson potentially influenced other jurors with prejudicial, inadmissible information. 3. A post-trial affidavit that suggests the foreperson was biased in favour of the prosecution and relied on information from outside sources. 4. Potential violation of the defendant's Sixth Amendment right to an impartial jury and due process under the 14th Amendment. The jury foreperson's knowledge of a dismissed grand jury indictment violates due process. The jury is only supposed to consider evidence presented at trial, not rumours. The foreperson's knowledge of the dismissed indictment for witness intimidation, which was never introduced at trial, was an extraneous influence that prejudiced the deliberations. Under Parker v. Gladden, 1966, a juror's exposure to extraneous information that influences deliberation violates due process. Turner v. Louisiana, 1965. Jurors must be insulated from outside influences. If a juror has independent knowledge of facts not introduced in trial, it compromises the fairness of the verdict. The jury foreperson's post-trial affidavit proves bias and a prosecution-friendly agenda. The affidavit repeats prosecution narratives about the dismissed indictment even though those allegations were legally rejected before trial. This suggests that the foreperson was improperly considering dismissed charges and outside opinions during deliberations. The foreperson was clearly not a neutral decision maker, but someone aligned with the prosecution's case. A good majority of the foreperson's affidavit relied on information from state witnesses and their online associates. If the foreperson relied on online rumours or prosecution-friendly sources to make decisions in deliberations, this is a clear due process violation. Under Smith v. Phillips, 1982, jurors cannot consider information from outside sources when deciding a verdict. If the jury foreperson was consuming biased outside information from prosecution-friendly sources and using it in deliberations, this tainted the entire jury process. The affidavit and statements by other juries is direct evidence that the foreperson was improperly influenced and should have not even been on the jury. This issue is squarely within the purview of the habeas review. The 6th and 14th Amendments guarantee a defendant's right to an impartial jury. Juror misconduct involving outside information is a well-established basis for federal habeas relief. Under McDonough Power Equipment versus Greenwood 1984, if a juror is dishonest or brings in outside knowledge that influences deliberations, it is grounds for overturning any verdicts. Under Warger versus Schewers 2014, juror bias that impacts deliberations is a constitutional violation. All of this strengthens the habeas petition because 1. The jury foreperson had prior knowledge of an uncharged, dismissed accusation against the defendant and may have used it to influence deliberations. 2. The foreperson's affidavit reveals that they continued to side with the prosecution even after the trial. And 3. The foreperson relied on sources outside of trial, including social media and state witnesses' statements, to justify concerns about juror safety, demonstrating clear bias. Does the fact that the jury foreperson contacted the state while other jurors contacted the defence matter? Yes, this is an extremely significant point. The jury foreperson's decision to reach out to the state immediately post-trial, before any other jurors spoke up, raises serious concerns about bias, improper influence, and a possible pre-existing relationship with the prosecution. As the first jury member to come forward, they didn't do so to report concerns about fairness or deliberation issues. They went straight to the prosecution to talk about prosecution-friendly issues. This is highly unusual. Typically, if a juror has concerns about the verdict, they would 1. Express those concerns to the court, 2. Remain neutral and avoid aligning with either party, or 3. Not advocate for the prosecution or its narrative. Under Smith versus Phillips, 1982, jurors must remain neutral and free from outside influence. If a juror actively aligns themselves with the prosecution after trial, it raises serious concerns about the impartiality during deliberations. The foreperson has effectively acted as an extension of the prosecution rather than a neutral juror. Their decision to immediately advocate for the state suggests that they were never impartial to begin with. If the foreperson was aligned with the prosecution, they may have deliberately suppressed dissenting votes during deliberations. Because the other jurors reached out to the defence, it supports the claim of a rigged deliberation process. After the trial, 5 jurors came forward, but they reached out to the defence, not the prosecution. Their statements supported the claim that the jury foreperson prevented them from reporting their acquittal votes on 2 charges. The jury foreperson's quick alignment with the prosecution, combined with the other jurors' later outreach to the defence, suggests that the foreperson was working to maintain a particular outcome. This reinforces the argument that the foreperson manipulated deliberations to favour the prosecution. The foreperson's affidavit did not simply discuss the trial, it focused on the dismissed witness intimidation charge, which was never presented in trial evidence, at least not in front of the jury. And it all amounts to juror misconduct.